It is precisely 7:01 on a Saturday morning. You are exhausted. You've been working 50 hours a week trying to keep up with the rising cost of groceries, utilities, and your mortgage. This morning was supposed to be your only chance to sleep in, to clear your head, to just breathe. Instead, your eyes fly open to the aggressive buzz of an unknown number. Your stomach drops. Your heart starts racing. Before you even answer, you know exactly who it is. It's a third-party debt collector, or maybe an aggressive subprime lender calling to demand money you simply do not have right now. If this scenario sounds familiar to you, I want you to take a deep, slow breath, because what that debt collector just did by calling your phone at 7:01 a.m. isn't just rude and it isn't just annoying. It is a flagrant violation of federal law. Hi, I'm Sean Quinlan, a consumer protection and bankruptcy attorney practicing right here in Pennsylvania. Today, we are breaking down the definitive legal handbook on debt collection. We are going to expose the exact tactics collectors use every single day that are completely illegal. We're going to look at the powerful laws designed to protect Pennsylvania citizens. And most importantly, I'm going to show you how to build an absolute legal brick wall around your family that forces them into permanent silence. The FDCPA versus aggressive collectors. Most people who are struggling with debt feel completely powerless. They assume that because they owe money, they have forfeited their rights as human beings. They think they just have to take the abuse, the late-night threats, and the constant digital stalking. I am here to tell you that is absolutely false. Debt collectors have very strict boundaries established by the United States government and the Commonwealth of Pennsylvania. They count on your ignorance to break these rules. Let's change that right now. The Federal Shield, decoding the FDCPA. Let's start with the foundation of your protection, a federal statute known as the Fair Debt Collection Practices Act, or the FDCPA. This law was enacted by Congress because they recognized that aggressive, deceptive, and abusive debt collection practices contribute to marital instability, job loss, and severe invasions of personal privacy. The FDCPA applies strictly to third-party debt collectors, the collection agencies, debt buyers, and law firms hired by original creditors to hunt down past due accounts. Here are the absolute statutory boundaries that these collectors cross every day, assuming you won't call them out on it. Rule 1. The clock rule. Collectors cannot contact you before 8 lower a.m. or after 9 p.m. local time. Doing so violates federal law. Rule 2. The workplace ban. If you tell a collector your employer prohibits personal calls, they are legally forbidden from calling your workplace again. Rule 3. Harassment and deception ban. Debtors' prisons do not exist. Collectors cannot harass you, use profanity, call repeatedly, or falsely threaten arrest or pose as law enforcement. Rule 4. The privacy rule. Collectors cannot reveal your debt to third parties. They may contact them only once to find you. The Pennsylvania Advantage, the FSUA. Now, everything I just told you covers third-party collection agencies under federal law. But what if it's the original creditor calling you? What if it's the actual credit card company, the actual bank, or the actual auto lender that you originally signed the contract with? Under the federal FDCPA, original creditors are generally exempt, but because you live in the Commonwealth of Pennsylvania, you have a massive advantage that residents of many other states do not have. In Pennsylvania, we have a state statute called the Fair Credit Extension Uniformity Act, or the FSUA. This law is found at 73 Pennsylvania Statute Section 2270.1. What makes the FSUA so incredibly powerful is that it takes almost all of those strict behavioral rules from the federal FDCPA, the bans on early morning calls, workplace harassment, deceptive threats, and privacy invasions, and it legally applies them to original creditors as well. This means if a major national bank or an online personal loan company is calling you at 7:30 a.m. in Pennsylvania or harassing you at work after you told them to stop, they are violating Pennsylvania state law. The FCWA makes a violation of its terms a deceptive business practice under our state's unfair trade practices and consumer protection law. That means you don't just have the right to complain, you have the right to sue them for actual damages, up to 3 times your actual damages and your attorney's fees. Let's talk about documentation. If you want to hold these companies accountable, you must become a meticulous record keeper. Every single time your phone rings, do not just reject the call or scream at the collector. Take a screenshot of your call log. Write down the exact date, the exact time, the name of the company displaying on the caller ID, the phone number they called from, the name of the agent you spoke with, and a detailed summary of exactly what they said. If they threaten you, write it down verbatim. If you tell them to stop calling you at work, write down the exact minute you gave that instruction. This log is the ammunition your attorney needs to turn the tables on them. The ultimate fix, the power of the automatic stay. Keeping a call log and sending cease and desist letters can be effective temporary tools. You can mail a collector a certified letter stating, "I refuse to pay this debt. Cease all communication with me under 15 U.S.C. Section 1692C, and they must stop calling." But let's look at the harsh reality of that strategy. Stopping the phone calls does not erase the underlying debt. If you owe $10,000 and you force them to stop calling you, that collector has only one logical next step to recover their money. They are going to hand the file to a collections attorney, file a formal civil lawsuit against you in your local Pennsylvania Court of Common Pleas or before a magisterial district judge, and try to get a judicial judgment against you. If you want to stop the phone calls, stop the letters, stop the lawsuits, and completely wipe out the debt all at the exact same time, you need a tool that is far more powerful than a simple cease and desist letter. You need the single most powerful injunction in the entire American legal system, the automatic stay. The automatic stay is a federal statutory order issued under Title 11 of the United States Code, Section 362. It is triggered automatically the exact microsecond your bankruptcy attorney files your Chapter 7 or Chapter 13 petition with the federal bankruptcy court. It does not require a judge to review your case first. It does not require a hearing, and it does not require the consent of your creditors. It is an immediate, absolute federal legal brick wall. The moment that petition is filed, a federal injunction descends upon your life. By law, every single creditor, collector, debt buyer, and attorney in the country must immediately freeze in their tracks. They cannot call your phone. They cannot send you a collection letter. They cannot file a lawsuit against you. If they have already filed a lawsuit, that lawsuit is instantly frozen in place. If they have scheduled a sheriff's sale on your home, that sale is canceled. If they are attempting to repossess your car, the repossession agent must step away from the vehicle. What happens if a debt collector ignores this federal order? If a collector calls you even once after receiving notice of your bankruptcy filing, they are in willful contempt of a federal court order. Under Section 362K of the Bankruptcy Code, the court must award you actual damages, including your attorney's fees, and in many cases, the court will hit that collector with massive punitive damages just to teach them a lesson. I've had cases where collectors were forced to pay thousands of dollars directly to my clients because they were arrogant enough to ignore the power of the automatic stay. The takeaway today is incredibly simple. You do not have to live your life in fear of your phone. You do not have to endure the humiliation of 7 spam collection calls, or workplace harassment. The laws of the United States and the Commonwealth of Pennsylvania were specifically designed to prevent this exact type of economic bullying. If you are ready to put an end to the harassment, if you are ready to replace the constant fear with a clear, legal, ironclad strategy, let's talk. Stop hiding from the phone and start fighting back with the law on your side. Click the link in the description below or head over to our website to schedule a completely free, 100% confidential financial strategy consultation. We will look at your unique situation, look at your debts, and figure out the exact path to get you the peace of mind you deserve. If you found this video helpful, make sure to hit that subscribe button, click the notification bell so you never miss an update, and drop a comment below if you've ever dealt with an aggressive collector. I'll see you in the next video.